Larceny Laws in New York by criminal defense attorney Andrew M. Stangl. New York larceny laws overview. Larceny is the name New York calls theft-related crimes. Larceny is defined as knowingly and intentionally taking property, which may be tangible or intangible, that belongs to another person, and for an extended period of time or permanently. Depending on the type of property that is allegedly taken, the circumstances of taking, and the value of the property, larceny may be either charged as either misdemeanor or a felony. Petit larceny in New York. The term larceny covers a variety of related crimes that carry a wide range of possible penalties. Petit larceny may be charged when property of any value is allegedly taken. New York's Petit Larceny statute, Penal Law Section 155.25, states a person is guilty of petit larceny when he or she steals property. Petit larceny is a misdemeanor and is most commonly charged in New York when shoplifting is alleged. Petit larceny in New York. Petit larceny is a Class A misdemeanor and is punished by up to 1 year in jail. Petit larceny also carries a possible penalty of 2 or 3 years of probation, or a split of up to 90 days in jail and either 2 or 3 years probation, a conditional discharge. In practice, however, first, second, and even third petit larceny offenders are rarely sentenced to jail if convicted of the crime. In fact, an aggressive defense attorney may be able to obtain an alternative to prosecution and conviction of the criminal offense. Petit larceny in New York. The two most common outcomes an aggressive defense attorney may achieve when petit larceny is charged are adjournment in contemplation of dismissal, ACD, when a defendant successfully completes all terms associated with a larceny-related ACD. The case is dismissed and sealed after 6 months. Some common terms of an ACD include avoiding an arrest, community service, restitution. Disorderly conduct in New York. Disorderly conduct is classified as a violation and not a crime. Like an ACD, there may be terms associated with a plea bargain to disorderly conduct, such as community service or restitution. While a conviction of disorderly conduct is not considered a crime and does not give a person a criminal record, it is still considered a conviction. Grand larceny in New York. In New York, all criminal allegations of wrongful taking crimes are classified as larceny, which is defined in Penal Law Section 155.05. There is no separate statute for embezzlement, theft by deception, or extortion. Thus, such allegations are charged as grand larceny. In addition, unlike other states, New York does not have a separate law regarding automobile theft. Rather, each of these variations, such as embezzlement, theft by deception, or extortion, is charged as larceny. The degrees of larceny commonly depend on the value of the property that is allegedly taken. Grand larceny in the 4th degree. Grand larceny in the 4th degree in New York, Penal Law Section 155.30, may be charged in a variety of circumstances, including, allegedly, taking property valued at more than $1,000, taking property directly from a person, taking a car or motorcycle, taking a debit or credit card, and committing extortion. Grand larceny in the 4th degree is a Class E felony, which is punishable by up to 4 years in prison. Grand larceny in the 4th degree. The specific allegations of a larceny case may alter the level of crime that is charged. For example, allegedly taking an inexpensive purse or wallet would be normally charged as petit larceny, a misdemeanor. But if that purse or wallet contains a credit or debit card, the misdemeanor crime could be charged as felony grand larceny. Similarly, allegedly picking up a mobile phone from a restaurant table while the owner is in the bathroom could be charged as petit larceny. But allegedly taking the same mobile phone from the owner's back pocket when he or she is not paying attention could be charged as grand larceny. And taking property from a person by force is usually charged as robbery, which tends to be a more serious crime than larceny. Grand larceny in the first, second, and third degree. Grand larceny in the third degree, Penal Law Section 155.35, may be charged if the value of the property allegedly taken is worth more than $3,000 and up to $50,000. The crime is a Class D felony and is punished by up to 7 years in prison for a first felony offender. Grand larceny in the second degree, Penal Law Section 155.40, may be charged if the value of the property allegedly taken is worth more than $50,000 and up to $1 million. The crime is a Class C felony and is punished by up to 15 years in prison for a first felony offender. Grand larceny in the first degree, Penal Law Section 155.42, may be charged if the value of the property allegedly taken is worth more than $1 million. The crime is a Class B felony and is punished by up to 25 years in prison for a first felony offender. Criminal possession of stolen property in New York. Criminal possession of stolen property in New York, which is often charged with larceny, is defined as knowingly possessing stolen property without the intention to return that property to the rightful owner. However, where a prosecutor lacks evidence regarding the actual theft, but a defendant has allegedly been found in possession of the stolen property, criminal possession of stolen property will be charged without larceny. Like grand larceny, criminal possession of stolen property has several degrees. Criminal possession of stolen property in the fifth degree is classified as a misdemeanor. Criminal possession of stolen property from the first to fourth degrees, which are felonies, track with the degrees of grand larceny, are based on the same monetary values. As a former prosecutor and current criminal defense attorney in New York, Andrew Stengel has successfully handled misdemeanor and felony allegations of larceny and criminal possession of stolen property. Visit the website of Andrew Stengel for more information, STENGELLAW.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.